Introduction. Legal capacity refers to the ability of individual or entities to enter into legally binding contract. For a contract to be valid, all parties must have the capacity to understand the terms and consequences. Key factors affecting capacity include age, mental competence, and legal status. Minor and mentally incapacitated individuals may lack capacity, making their contract voidable. Businesses must ensure capacity to avoid dispute and protect vulnerable parties.
Okay, now I will explain about case 1. It's about mentality capacity case. And the case I will discuss about is the Hart v. O'Connor at the time of 1985. The fact of this case is, in O'Connor vs. Hart, Jack O'Connor, an elder man who has unknowing of unsound mind, sold his farm to Hart, and then Hart, unaware of Jack's mental incapacity, conducted fair negotiation with Jack's solicitor. So it's said that mentality incapability in property vendor enter a contract with Hart. The vendor later sought to be void the contract. Then first issue is a contract by a mentally incapacitated person void or voidable? Second is, can it be ratified upon regarding capacity?
Alright, I'm continuing the case 1, Hart versus O'Connor, 1985. Alright, under Malaysian law, Close Contract Act 1950. Alright, we have two sections that involved in this case. First section is section 11 and second section is section 12. Section 11 requires parties to be aged, sound mind and not disqualified by the law. And second section is section 12. Section 12 is define sound mind and provide for lucid intervals. Alright, my conclusion for case 1, Hart versus O'Connor, 1985. Alright, the contract was voidable but not yet void. If the other party knew the incapacity, the contract could be voided. If the vendor could ratify the contract upon regaining capacity.
Now I'm going to talk about the case 2, which is Court vs. Overton 1833. In this case, a mirror, which means that court enters into a contract to join a business partnership and paid £100 as a deposit. However, the minor later sought to resign the contract and claiming it was in doubt by misrepresentations. The minor requests a refund of the deposit paid. For the issue of this case, first is, can minors disfirm contracts? The case raises the question of whether a minor who lacks full legal capacity can disfirm or resign a contract they enter into. And the second one is about, can the minors recover the payments made in voidable contracts? Another issue was whether a minor who resigns a voidable contract is entitled to recover any payments already made under the contracts. Now, according to the Malaysia law, which is Contract Act 1950, in section 11, a contract with a minor is generally voidable. Minors are considered to lack the capacity to enter into the binding agreements. And the second one is voidable contracts. Contracts induced by the misrepresentations are voidable at the option of the innocent party, even more so if the party is a minor. For the decisions, the court held that the contract was voidable since the minors entered into the contract based on the misrepresentations. It was deemed voidable at the minor's options. Besides that, the minor could also recover the deposit. The minor was entitled to recover the £100 deposit because the contract was resigned due to the misrepresentations. This reflects the principle that law protects the minor from being unfairly disadvantaged in the contracts.
So I will be discussing a landmark case in company law, which is Ashbury Railway Carriage vs. Richer, 1875. This case deals with This case deals with the doctrine of ultra vires, which determines the limits of a company's power based on its memorandum of association. Facts of the case. In this case, a company entered into a contract that was outside its stated objectives, as defined in its memorandum of association. When the contract didn't go as planned, the company argued that the contract was invalid because it went beyond its legal defined powers. This case raised two key legal issues. The first one, whether the contract valid under the company's object as stated in its memorandum. And the second one is whether the shareholders of the company ratify this contract and make it valid.
So I'm going to continue our case, which is the Ashbury Railway Carriage versus Richer. So there are two sections that were involved in this case, in which the first one is Section 10(1) of the Contracts Act 1950. All agreements are contracts if they are made by the free consent of parties competent to contract for lawful consideration and with a lawful object, and are not hereby expressly declared to void. And the second section is Section 11 of the Contracts Act 1950. Every person is competent to contract who is of the age of majority according to the law which he is subject, and who is of sound mind, and is not disqualified from contracting by any law to which he is subject. So the decision that has been made is the contract was ultra vires, the company's objects as outlined in its memorandum of association. Any act beyond the company's objects was void and could not be ratified, even if all shareholders agreed to it. The memorandum of association served as the constitutional document, limiting the company's powers to those expressly stated or implied.
For the fourth case law, which is Freeman and Lockyer v. Bauhaus Park Properties, 1964, the fact is, an architect contracted with a company based on a director's action. Through the director lacked formal authority, the company refused to pay, claiming lack of authority. The central legal issues in this case include: does apparent authority by a company? Are third parties protected when acting in good faith?
This case in Malaysian law, the Contract Act 1950, Section 135 defines internship as a relationship where one person is employed to act on behalf of another. The decision is the company was liable due to apparent authority. The parties can rely on a company's representation of authority.
Hi, so today I'm going to talk about the case of Miss Olcott v. Skinner 1887. So this case about a young woman entered into a religious order under the authority of Miss Skinner. And when she joined, Miss Olcott transferred property worth 4.3 million to the religious order as a gift. Miss Olcott thereafter withdrew from the order and attempted to recover her property on the ground that she was subject to undue influence to make the transfer, being in a position of dependency and influenced by and over Miss Skinner. So the issue here, whether there are presumption of undue influence due to the relationship of trust and authority between Miss Olcott and Miss Skinner.
I would like to continue the case of Olcott vs. Skinner in the year 1887. In this case about undue influence, it is a case decided under Malaysian law, specifically the Contract Act 1950. This case focused on Section 16(1) of Contract Act 1950. This states that contracts induced by undue influence are voidable. This means that the affected party has the rights to cancel the contract. The decision took by the court found that there was undue influence in this case. However, the court has denied the recovery due to the plaintiff delay bringing up this case to the court.
In our conclusion, legal capacity ensures fairness in contract under the Malaysian Contract Act 1950 minus a mentally incapacitated individual has limited capacity. Corporation must act within legal powers. Contract under undue influence or without authority may be voidable. This principle reduces risk in transaction.